Hi, everyone. Thanks for joining me today here for my talk on AI IP in your code, what developers need to know. I hope you're able to walk out of today's session feeling a little bit more informed and mindful about the copyright licensing implications of AI-generated code, and perhaps with a new perspective on vibe coding. So in terms of my background, I am a former lawyer turned Python user and enthusiast. I'm also a PyLady San Francisco organizer. I live here in San Francisco with my adorable yet extremely high maintenance Shepherd Husky mix dog. And before I jump into the talk, I'm going to do a quick disclaimer. So I am no longer practicing law. My license is on inactive status. And when I did not practice in intellectual property. But just note that regardless, nothing in this presentation should be construed as anything except for informational purposes. There's no legal advice herein. And I'll also note that this presentation is going to be highly US-centric, so we're primarily only going to focus on US law. And with that, I'm going to jump into the agenda, and we're going to start with a quick overview of IP law, then we're going to jump into some copyright law implications of AI-generated code, before finally talking about some tools and solutions for handling AI-generated code. So with that, let's jump in. I think an interesting question to start from is, why do we have intellectual property rights? So intellectual property covers this intangible property. Normally when we think about property, it's something tangible that we can feel and touch. So here, the idea is that we wanted to create a new set of rights for creative expression, creative invention, and to bolster innovation. And in the US, this is actually constitutionally mandated. So this right to creative works starts from the Constitution, and then there's a number of statutes and case law that follow. And so in the US, this right is meant to be temporary, so eventually the right expires and the creative work goes back to everyone's benefit in the public domain. And depending on the specific intellectual property in question, the right might have a different term of expiration. But then after, it goes back to the public domain and anyone can freely enjoy it without restriction. And in terms of that right, well, what does it cover? What is intellectual property? There's three big categories that we'll primarily be talking about copyright today. There's trademarks, those involve branding and logos. There's patents, which involve inventions and could be related to software code, but we're not going to talk about that today. And then there's copyright, which heavily can affect code because code is protected under copyright. And what is copyright? Well, it's the right to ownership of a variety of different types of creative works, ranging from things like photographs, television, literary works, and in the vein of literary works, that's actually how software code achieves protection as a literary work. And what rights does copyright give you? Well, basically you have the right to control the use, distribution, and modification of the work. And that right to modification is quite important. That means that you have control and protection over derivative works of the original work. But let's think about how we typically think about copyright within the framework of code. And typically, we're not thinking about copyright as a concept. We're thinking about software code licensing. And as you can see in this very much not drawn to scale Venn diagram, there's 4 bubbles. The first is proprietary. That is a huge bubble. So proprietary is that type of code base that's availing itself of typical copyright protection. So basically barring folks from using, modifying, or distributing the code without permission or payment. And then there is a smaller bubble, public domain. It doesn't really affect software code as much because it's such a new type of literary work, so typically the term hasn't expired. But just for example's sake, you could think of something as being in the public domain. So Google's PageRank patent expired, so that's now in the public domain. Similarly, the original Winnie the Pooh copyright expired, and that original Winnie the Pooh is now in the public domain. So just some examples of things that are now in the public domain. But oftentimes, we actually are thinking about open source when we think about software code licensing. And the ability to add an open source license to software code still is derived from the copyright over that code. So if you didn't have copyright, it would be hard to attach the kind of software code licensing that we do. So you're saying, I'm the copyright holder, I can add this license. And then when we think about open source licensing, there's two primary areas. The first is permissive open source. And so that would be something like the MIT or Apache license. And with the MIT or Apache license, the idea is that we're allowing free and open use of that code. And what does that mean? Well, it means that there's no restrictions on your use, your distribution, or your modification of the code for the most part. But there is still a right of attribution that follows in downstream versions. And that's very important because that means that although they've disclaimed many of the typical rights afforded under copyright, they haven't disclaimed this right of attribution. So if you're using open source code that's permissive, you still have an obligation to attribute to the original author. So then on the other side of things, there's another type of open source code called copyleft. And that would typically be considered, as an example, the GNU General Public License, so also known as the GPL. And the GPL goes a step further. It says, we're going to work really hard to make sure that this is free and open source by adding additional restrictions. And those restrictions are layered on via contract. So although the right to impose the restrictions is based in copyright, the additional restrictions are contractual obligations that you enter into when you're interacting with the code. So because they've added these additional restrictions to make things free and open source, those typically involve restrictions on being able to freely and openly use the code in such a way that changes the license away from GPL. So you have to use a license that's GPL or stronger. So in that way, it prevents the code from flowing back into this proprietary bubble. It means that in all downstream uses, people should be able to use, modify, and distribute the code freely within the constructs of the GPL. But as you can see, there is still this big overlap between copyleft and proprietary, even though the GPL is saying, well, we want the code to always be free and open to everyone. And the reality is that there are a lot of companies that are still incorporating copyleft code in their proprietary code bases. So interestingly enough, there's an advocacy group right now, the Software Freedom Conservancy, that is working to change that and enforce these GPL code provisions against companies that are incorporating that code into their proprietary code bases. And now that we have a sense of what is protected in the software world and how copyright affects us as developers, there's an interesting question that arises. Who can copyright AI-generated code? So let's say that I create some really amazing prompt, and from that prompt, I'm able to achieve a fully functional program, and it's thousands of lines, works right away, and just seamless, easy program. I'm super excited. I'm like, all right, I'm going to copyright this. I'm going to take this to the bank, but actually, I won't be able to achieve copyright. And in part, that relates to this very interesting number of cases called the monkey selfie disputes. And so, as a background, the British nature photographist David Slater went to Indonesia to capture photos of macaque monkeys, and when he did so, he set up a tripod that allowed the monkeys to photograph themselves. And so they took a number of monkey selfies, like the one on the screen, and basically then David Slater incorporated that in his compilation of nature photographs, and when he found out that Wikipedia had placed one of these monkey selfies on their page, he requested that they remove it. So he sued Wikipedia, and Wikipedia actually prevailed because they argued, well, actually, the monkeys took the photos, so you don't have copyright. And he was unable to assert copyright over the monkey selfies. In a subsequent case, Naruto versus Slater, PETA, on behalf of the monkeys, sued David Slater, alleging that, well, the monkeys deserve compensation for the photos, so you included them in your book. It was a compilation. He had his own copyrighted photos and then these non-copyrighted photos, and the court ruled, actually, the monkeys don't get copyright because in the US, there's a threshold requirement for human authorship, so only human authors can attain copyright. And in the same vein, AI-generated code also will not achieve copyright because AI is the author. But that leads to the question, of course, of, well, oftentimes when you're working with an AI code tool, you're not simply just taking all of that and assuming that it's yours. You're usually interacting with it. You might be modifying it and changing it. So here are a few illustrative examples to understand how that might play out. The Copyright Office had this interesting graphic novel from creator Chris Kashtanova, and basically Chris Kashtanova took a number of panels created by Midjourney. So they prompted Midjourney, they got individual panels, and then they assembled them into a graphic novel and added their own text and captioning. And the Copyright Office found that the individual panels were not copyrightable. The graphic novel as a whole was copyrightable. And the reasoning there is that the human authorship was only attributable to the compilation of the photos in a creative way. I mean, not the photos, the panels. And also to the extent that there was human authorship of the text and captions, that was protectable. So limited protection. Similarly, there was this other piece of artwork. This is actually an award-winning piece of artwork from artist Michael Allen. It won Jason Allen. It won an award in a Colorado art contest. And basically, Jason Allen similarly was not able to attain copyright over this image. He argued that I put so much effort in. There was over 600 prompts, and I also did some Photoshop editing, and then I upscaled with another AI tool. And the Copyright Office said, well, you only get human authorship for the Photoshop editing, and therefore that's the only part that is copyrightable. The photo itself is not copyrightable, except to the extent of the Photoshop edits. So that brings us to our next question. How are we even making all of these crazy interesting photos or AI-generated code? Well, basically, the large language models that we rely on for AI-generated code generation are based on these massive training data sets. And those massive training data sets include pretty much the entire internet scraped, but also large collections of books. And it's actually turned out in copyright litigation that we found out that a lot of these large collections of books were pirated collections of books. So there are so many different questions about, was the training itself an infringement on the copyright holder's rights? Was the use of pirated books infringement? Like, you know, if you had used a legally purchased copy of the book, would that change this idea of whether or not there's infringement? There's questions about, if I take a book, rip off the bindings, scan the book, and then create a digitized version of that book, is that copying the book in a way that constitutes copyright infringement? And all of these very fascinating questions are being considered right now in copyright litigation. But that's kind of on the input side of things. We have all these questions about copyright infringement on the input into LLMs. There's also questions on the output side of things. So here's an example from my own ChatGPT account. This is kind of an older example, still with ChatGPT 4. But as you can see, I said make a comic of a dog saying this is fine, and it knew to retrieve this particular extremely famous meme. It's the Casey Green gun show comic strip. And this is an example of regurgitation. So sometimes when you're using these LLMs, they're spitting out either identical copies or substantially similar copies to what was actually included in the training data. And that is a concern for us as developers, because let's say that instead of getting this comic that I immediately recognized as copyrighted, what if I got the Linux kernel and I didn't for some reason recognize it and I included it in my code base, that would be problematic. But in terms of the output side, we need to take some responsibility for how we're interacting with outputs. But in terms of the input side, the LLM providers are arguing that even if they did commit copyright infringements, they have this argument called fair use. And I have the 4 different factors for considering fair use up on the screen. I will note that these factors are not in any way equally weighted. So depending on the case, they have very different weights associated with them. So whereas some courts are finding that the use might be more important in terms of how transformative it was, other courts might be more interested in the effect upon a work's value, so more of a market harm question. And fair use only applies if there's already a finding of copyright infringement. So assuming that courts decided actually there's no infringement from using copyrighted data and training data, then this wouldn't be a question. This is only a question as a valid defense for copyright infringement that allows you to proceed. So we've already gotten a little bit of insight from courts on how they feel about this, and it's a yes, yes, no, which is interesting. So we've gotten mixed opinions. We don't really have a definitive opinion. The US Supreme Court hasn't issued an opinion yet. These are all lower courts. And in the first case, Anthropic versus Bartz, we've seen that the court actually found that not only was the use of copyrighted materials in training data fair use, the transformative nature was spectacularly so, exceedingly so, quintessential fair use. So it's kind of interesting to see that result. In that same opinion, however, the judge found that the use of shadow libraries, where you've accumulated mass numbers of copyrighted books, to the extent that those libraries are used for anything but training, that is not fair use. So the shadow libraries is in question. And then in another case, the Kadri versus, and actually I'll pause and go back to Bartz versus Anthropic for a second. That case actually just settled for $1.5 billion in a class action settlement, the largest ever for copyright. So that's kind of the end of the line for that case. So it's already been approved tentatively by the judge. But in another case, Kadri versus Meta, we also had a finding of fair use on a much weaker basis. In that case, the judge said, yes, there's fair use, but there's actually a major issue in regards to the market dilution of the works in question. So this was a lawsuit filed by authors. Their arguments did not contain anything about the effect of market dilution from outputs from LLMs affecting their work. And the judge said, well, actually, if you had shown market dilution of your works as competing to the outputs from LLMs, maybe I could have found fair use. So very interesting, weaker, yes. And this judge also found that the use was transformative, highly transformative, in fact, but the major question in his mind was, is this creating market harm? And then in another case that's quite distinguishable, there was no finding of fair use, but that case didn't involve generative AI, so quite a different fact pattern. And as you can see, lots and lots of litigation on these matters, so I think we're going to get a lot more opinions and a lot more insight on how the legal system feels about what's happening right now. There's over 50 cases in the US, as you can see on this map, over 75 cases globally. But let's segue into how we need to deal with this reality as developers. So I'll say a lot of the best practices I'm going to talk about aren't specific to AI-generated code. They're really just about having good practices that are ensuring that you're not violating licensing and able to interact with your code effectively. So first and foremost, I would say use AI-generated code very carefully. Use code that you understand. That's not just going to help you with AI-generated code. That's going to help you to not only avoid licensing disputes, but it will help you to debug your code later. It's going to help you to avoid unforeseen security vulnerabilities that might be hidden in your code. So that's definitely very important. Use shorter snippets. I think I glossed over this a bit, but when we talk about copyright, you're only able to copyright the creative expression. That's why I keep talking about things that are creative and expressive. but the ideas therein are not copyrightable. So for instance, for item in items, print item, not copyrightable. If it were, we would be in bad shape. It'd be really hard to write new programs. So if you use shorter snippets of AI-generated code, or even for code that you're borrowing online, then you're less likely to encounter that you've incorporated code that's already licensed. And even if it were licensed, it might just be simply an idea that is not protected. So use shorter snippets. You also want to prompt very carefully. If you're using good, clean prompting practices, you're less likely to get copyrighted output. So don't prompt, for instance, in the style of, or in some way that might goad the LLM into providing you something that is already copyrighted material, and then you won't have to worry about licensing implications of that code. Also, follow your employer guidelines. They're there for a reason, and you don't want to be in violation of those. When in doubt, consult with your legal team. In the same vein as being mindful of the generations that you're making, you also want to be checking for licensing issues. So you want to check your AI-generated code. You also want to check not just for the AI-generated code, you want to be checking in general for licensing issues, right? So you want to look at your imports and make sure that your imported modules don't have licensing conflicts. You want to be looking a little bit deeper. If you're borrowing code from something like Stack Overflow, you want to make sure that doesn't have issues either. And then one thing you can do if you're using a tool like Copilot is you can block public code suggestions, and that means that if the code that it's going to output matches a public repository, they're not going to feed it to you as an output. So that's another way to avoid some of these licensing questions very easily. And then in order to check for licensing, you can use license scanners or source composition analysis tools to check your code. Really popular free and open source tool called Visology will allow you to check to see if you're using licensed code, and also it will look to see if there's keywords or other signs of such licensing questions. On the other hand, a source composition tool will allow you to go in a little bit deeper and see on the snippet level if there are potential licensing issues. But what's great is that you can actually implement these tools on a pull request level by implementing them in your CI/CD process, and that way you kind of automate some of these steps and you have licensing flags that you can look at. Also, you want to consider this during your code reviews to make sure that when you're reviewing your other coworkers or friends' codes, you're also considering these questions. You also want to document your use of AI-generated code. So document or tag where your borrowed code comes from or your AI-generated code. And then in that way, you are already flagging yourself to see like, oh, is there going to be a licensing issue? Or, oh, there's a flag from my license scanner, and that makes sense because this was AI-generated. And then in the same vein, when you're identifying or tagging your AI-generated code, you can also be documenting your human contributions and consider if you want to copyright your code, you know which portions are protectable and which can be included in your copyright registration or copyright assertion in court if necessary. And then also you want to document your processes for clean prompting of AI to ensure that if you were in a situation where someone says that you are violating their license, you can show that you actually have clean hands, you've done your due diligence, it was either an inadvertent mistake or something that you can easily rectify. And then finally, consider terms of use. Read and understand the terms of use of the provider that you have. Avoid blind reliance on indemnification provisions that are saying that they're gonna like handle all these legal issues for you. You still have to do your due diligence. Consider the privacy protections that are offered on your inputs. So you wanna be very careful in prompting also not to reveal any confidential information. So consider especially being cautious with API keys, passwords, client data, and sensitive and confidential information. And then also consider the chain of like third parties that might be looking at your prompts, because if any of those have a data breach, that could also result in a leak of information that you've included in a prompt. And with that, I will wrap it up, and I'm happy to answer any questions, time permitting.
We're tight on deadline. We can ask 2 quick questions. One over here on the left.
Hi, this has been a great talk. I'm curious to see with the development and the licensing issues, have there been any, I'm sure there's probably a growing number of license prompt inputs. How would you be able to know if your prompt, if you thought of it or you found it online, could could that also be a licensing issue?
Yes, I mean, if a prompt itself could be copyrightable, so basically if a prompt is more than just an idea, if it's actually protected human expression, then that could be copyrighted, but then maybe it's shared under a Creative Commons license and you can use it. So yes, there are questions about the text in prompts as well and the copyrightability of those as well.